What's up, everyone? Welcome back to The Lawyer You Know. It's Peter Tragos, and today is truly a day of worlds colliding once again. We've got a civil lawsuit dealing with cryptocurrency and celebrity promoters. We've got legal precedent getting set. We've got questions getting answered, and we're going to talk through it today as Jake Paul and other influencers are being sued in a class action lawsuit for promoting cryptocurrency that had a pull the rug, a pump and dump kind of scheme to it. Now, did these social media influencers know? Should they have known? Can they be sued? What's the law say about it? What's the complaint say? We're going to talk about all of that today, and it's going to be fun. We haven't talked cryptocurrency since the Kleiman v. Wright trial. Maybe we'll get Kurt on to talk about how he feels about celebrity promoters for this stuff who don't know what they're talking about for the most part, and whether or not they should be promoting things like this. And I want to hear from you in the comments as to whether or not you think it's fair for advertisers and promoters, especially in today's day and age, where there are so many influencers on social media with millions of followers who basically do whatever they say. Should they be held responsible if they promote something that they don't really know what it is, but someone shows up and says, hey, here's a couple thousand or 100,000 or even millions of dollars. Just say you like this cryptocurrency. Say you like this business. Say they should shop at this store. Say they should eat at this restaurant. You don't know if the food's good. You don't know if the service is good. You don't know if it's a good deal. Is it fair to hold them accountable? That's really what I want to know from you in the comments. If you were on this jury, would you hold Jake Paul or Lil Yachty or Nick Carter responsible for promoting cryptocurrency? They have disclaimers that they're not financial advisors. They're not necessarily telling you what to do. They're just giving you a little tip here. Jake Paul made a tweet that said, I was early on Dogecoin and look how well that did. And now I'm early on SafeMoon, which is kind of the title of this lawsuit. So if you haven't already subscribed, make sure you hit that subscribe button to catch more videos like this and others, and hit the like button if you're interested in this content specifically. And we'll continue following this case if it gets enough interest, as always, because we want to bring you the content you're interested in. So as we start with just about any of these kinds of cases, we're going to start with the complaint itself. And the first page of the complaint, we can always learn a lot. It has the actual defendants, and I want to highlight some at the bottom, where you see Jake Paul, Nick Carter, and then the real names of some rappers that you may or may not know who have large social media followings who promoted something called SafeMoon. SafeMoon is a cryptocurrency, and hence the name. It was supposed to be a cryptocurrency that was safe. If you invested in it, nobody could mess with it, because as we all know from talking about the Wright v. Kleiman case, there's a lot of unknowns with cryptocurrency. There are experts, there are noobs, and there are some people in the middle that don't really know how it works, but everybody wants to be in on the new fad and they don't want to miss out on making a lot of money quick, right? There's no such thing as free lunch. But nobody wants to miss out on this get-rich-quick scheme. But investors should have the opportunity to invest into something fairly, just like anybody else, with a chance of going up or down. They should not get swindled, which is what the plaintiffs in this case are claiming happened. So to figure out the facts, we're going to jump to the nature of the case. Paragraph 2. This case arises from a scheme among various individuals in the cryptocurrency sector to misleadingly promote and sell the digital asset associated with SafeMoon, the SafeMoon tokens, to unsuspecting investors. Those are the normal people that bought into this. The company's executives, collaborating with several celebrity promoters, A, made false or misleading statements to investors about SafeMoon through social media advertisements and other promotional activities, and B, disguised their control over SafeMoon and a significant percent of the SafeMoon tokens that were available for public trading during the class period. Paragraph 3. In furtherance of this scheme, defendants touted the technological innovation of the company's token and related cryptocurrency wallet, as well as the ability for investors to make significant returns due to favorable tokenomics of the SafeMoon tokens. In truth, defendants marketed the SafeMoon tokens to investors so that they could sell their portion of the float for a profit. So I'm sure Kurt is not going to be very happy with me, but this is why I've always been hesitant to invest in stuff like this. I'm always worried. I don't know what I'm getting into, and this is going to happen. Because when you talk about tokenomics and the control over the cryptocurrency that the owners of the company have versus the investors, and how they can lie to you and you might not know it until it's too late. So what happened here is people built this company, SafeMoon. They get some social media influencers say SafeMoon is to the moon and, rising up and jump on the train and don't miss out and blah, blah, blah. And of course, people have such FOMO that they end up buying in large amounts. And what happens is when they buy, the stock prices go up. And as they go up, the owners of the company are selling out and pulling the rug and screwing the investors, which the investors are buying high. And as the owners are selling, it's coming back down. So they're losing value. So they bought higher than what they could sell at now. And instead, the social media influencers say, oh, this isn't a dip for SafeMoon. This is just us coming back to earth because we were so high. Keep buying, keep buying, keep buying. They kept pushing it. They kept on pushing it. And the social media influencers were a part of this because they were paid to promote this. And it's no surprise that in today's day and age, people are going to buy what social media influencers are selling. So they knew what they were doing here, the owners of the company. So no doubt, if the plaintiffs can prove this, they're going to get a lot of money back from these owners. But can they get money back from the social media influencers? That's the more interesting question for me. A Ponzi scheme is a Ponzi scheme. And if somebody sells you something that doesn't exist and they're insider trading, basically they're selling as you're buying and screwing you, if you can prove that, they're going to win against the owners of the company. Now, again, I said if they can prove that. But what about even if they can prove that against the company? Should the influencers and the promoters be held liable? What do you think in the comments? Let's first read the causes of action, then talk about what the state of the law is, because there have been other similar cases to this one. We're going to jump down to the bottom now to the causes of action. All right, we're going to start with the second cause of action again because we're focusing on the social media influencers. Violation of California Consumers Legal Remedies Act. At all relevant times, there was in full force and effect California law which prohibits various methods of unfair or deceptive acts or practices undertaken by any person in a transaction intended to result or that results in the sale or lease of goods or services to any consumer, including but not limited to misrepresenting the affiliation, connection, or association with or certification by another and representing that goods or services have sponsorship, approval, characteristics, ingredients, uses, benefits, or quantities that they do not have, or that a person has a sponsorship, approval, status, affiliation, or connection that the person does not have. Defendants engaged in business acts and practices deemed deceptive because of the conduct, statements, and omissions described above, including but not limited to the following: knowingly and intentionally concealing the executive defendant's specific roles and ownership interest in SafeMoon, knowingly and misleading making statements around the availability and functionality of the SafeMoon wallet when they knew or should have known that the wallet feature would not be ready for scheduled launch, knowingly and misleadingly making statements regarding the security of the company's liquidity pools for the SafeMoon tokens when they knew or should have known that the liquidity pools were designed in a way that allowed for the possibility of the liquidity pool being drained by defendants or other bad actors. One of the things they told them is that you couldn't take these tokens once you bought them, something like that. And D, knowingly and intentionally using and or failing to disclose the use of promoter defendants to instill trust in uninformed investors to promote the financial benefits of a highly speculative and risky investment in SafeMoon tokens in an effort to manipulate and artificially inflate the price and trading volume of the SafeMoon tokens and allow defendants to sell their SafeMoon tokens at that inflated prices. Now, we're separating these causes of action because nobody disputes that if the owners really said, oh yeah, buy these, they're safe, nobody can sell them, and then the owners could actually sell them for a profit, that could be fraud, obviously. But we're talking about what the promoters knew, because they're saying you instilled trust in uninformed investors so that the investor has no duty to do any research. If Jake Paul tells me to invest in something, I have to do it. It's what it's sounding like here a little bit. And to me, I'm not sure how I feel about that. Paragraph 193, as a direct and proximate result of defendants' unlawful, unfair, and deceptive practices, plaintiffs and class members suffered damages. Let's talk about the next cause of action. It is aiding and abetting. Under California law, paragraph 199, aiding and abetting requires not agreement, but the simple assistance. The elements of aiding and abetting liability have cited the elements of the tort as they are set forth in the reinstatement section of torts. and have omitted any reference to any independent duty on the part of their aider and abettor. Under California law, liability may be imposed on one who aids and abets the commission of an intentional tort. So we've heard about, aiding and abetting crimes and murder. And here, an intentional tort is something you do on purpose, like fraud. And you can actually have an aiding and abetting connection here in California. If the person, A, knows the other's conduct constitutes a breach of duty and gives substantial assistance or encouragement to the other to so act, or B, gives substantial assistance to the other in accomplishing a tortious result, and the person's own conduct, separately considered, constitutes a breach of duty to the third person. This is difficult to me because knows that the other person, meaning the promoters, had to know that the owners of SafeMoon were going to do this illegal stuff and pull the rug. I highly doubt they knew that. Highly doubt it. They don't want this trouble. Somebody else will pay them a lot of money to promote something. Or, so I don't think they win on A. Or B, give substantial assistance in accomplishing the tortious result. And the person, meaning the promoter's own conduct, separately considered constitutes a breach of duty. So they still have to prove that the promoter breached a duty they had to the third-party investors. And that's what we're going to have to see if the facts show that. Unlike a conspirator, an aider and abettor does not adopt as his or her own the tort of the primary violator, meaning they didn't have to actually pull the rug. Rather, the act of aiding and abetting is distinct from the primary violation, meaning pulling the rug. Liability attaches because the aider or abettor behaves in a manner that enables the primary violator to commit the underlying tort, which sure, they did that. They aided and abetted the primary violator to commit the tort, but did they actually breach a duty? Did they actually do anything wrong? The promoter defendants have previous knowledge and experience with making misleading promotional statements, with defendant Mayweather having nearly an identical experience with a previous fraudulent cryptocurrency promotion. And as such, knew or should have known that the marketing strategy employed by the executive defendants for the SafeMoon tokens was unlawful, deceitful, fraudulent, and or violated the terms of California, Florida, and New York state statutes described in this complaint. How did they know or should have known? That's what the facts are going to have to prove in order to hook these promoter defendants, in my opinion. By promoting the SafeMoon tokens on their social media platforms and through their reported conduct, the promoter defendants provided assistance that was a substantial factor causing the SafeMoon token price to both surge and do so long enough to allow defendants to sell their SafeMoon tokens for huge profits at the expense of their followers and investors. Without the help of the promoter defendants, the executive defendants would have been unable to use the misleading marketing strategy devised by Haynes and Davies, the defendants, and they would not have been able to commit the violations of California state consumer protection statutes. So they're saying without these promoter defendants, they would never have been able to do what they did here, the executive defendants. And while that may be true to a certain scale, they could have bought TV advertising. And that's the other thing. How far are we going to take this? If somebody pays ABC to run a commercial for SafeMoon and they're committing fraud, ABC can't get sued for that. They're just selling advertising space. We're in kind of a new world here. A similar case to this has already kind of gone through the judicial system. And the promoters of a Bitcoin type of cryptocurrency, it's not called Bitcoin. Let me give you exactly what it's called here so nobody gets angry with me. BitConnect. That's what it was called. This has happened with BitConnect, where promoters were sued and they said, we didn't directly sell a security to our followers or tell them they had to buy it. Therefore, this case should be dismissed. And it was dismissed, saying the promoters could not be held liable. However, recently, that has been reversed by the 11th Circuit Court of Appeals. So let's talk about it. All right, so what we're looking at here is, let me give you a little procedural history here. So the defendant promoters got the case dismissed. The plaintiffs refiled their complaint, amended their complaint to add in the fact that there were actually referral links that people clicked from these influencers to buy this BitConnect, trying to make that personal one-on-one connection to overcome the dismissal. That complaint got dismissed again. So they appealed it up to the 11th Circuit Court of Appeals. And we're reading right now the opinion of that court that reversed that dismissal and says that the social media influencers can actually be held liable. So what we're looking at here is the actual court's opinion. And we're going to start on page 3 with paragraph 2. The marketers insist that they cannot be held liable because the Securities Act covers sales pitches to particular people, not communications directed to the public at large. Not so. Neither the Securities Act nor our precedent imposes that kind of limitation. Solicitation has long occurred through mass communications, and online videos are merely a new way of doing an old thing. Because the Securities Act provides no free pass for online solicitations, we reverse the district court's dismissal of the Section 12 claim. So, BitConnect and its promoters stoked public enthusiasm for a new form of cryptocurrency, the BitConnect coin. All right, let's jump down to page 8, which kind of gives the court's actual opinion. We reviewed de novo a dismissal for failure to state a claim. In doing so, we accept the complaint's factual allegations as true and construe them in the light most favorable to the plaintiffs. What does this mean? Real quick, just a little side note. That does not mean everything the plaintiffs say in the complaint is actually true. It just means the judges say, if everything they say is true, can they win? Do they have a cause of action? Is there a reasonable jury that could rule in favor of the plaintiff? Because if not, if everything they're saying is true and they still can't win under our laws, then we need to dismiss this case. Now, if everything they say is true and they can prove this cause of action, we'll let the case keep going, and they still have to actually prove it's true before a jury. They still have to prove it's true. This is just for the judge to make a decision here. They assume all the facts are true to give the plaintiff every benefit of the doubt before they dismiss their claim. The only question here is whether a person can solicit a purchase within the meaning of the Securities Act by promoting a security in a mass communication. Carl, the defendant, insists that liability follows only when a seller directs a solicitation to a particular prospective buyer. Mass communications, in his view, are never enough. That rule would certainly go a long way toward eliminating liability for the promoters here and for others who champion dicey investments through modern communication channels. What does that sound like? Sounds like the SafeMoon case with Nick Carter and Jake Paul and all those promoters. The problem for those promoters is that nothing in the Securities Act makes a distinction between individually targeted sales efforts and broadly disseminated pitches. The Securities Act prohibits a person from using any means or instruments of transportation, of communication in interstate commerce to sell an unregistered security. Technology has opened new avenues for both investment and solicitation. Sellers can now reach a global audience through podcasts, social media posts, or, as here, online videos and web links. But under the district court's cramped reading of the Securities Act, a seller who would be liable for recommending a security in a personal letter could not be held accountable for making the exact same pitch in an internet video or other forms of communication listed as exemplars in the Act, like circulars, radio advertisements, and television commercials. A seller cannot dodge liability through his choice of communication, especially when the Act covers any means of communication. We decline to adopt that interpretation that both contradicts the text and allows easy end runs around the Act. So, what the Court of Appeals is saying here, we are not letting you off easy just because you post on Twitter versus send a direct mailing letter. We are not giving certain distinctions. We are holding everybody accountable that knew or should have known. And again, this is important because I'm sure in this complaint, just like in the SafeMoon complaint, they allege that these promoters knew or should have known of the fraud. So I think they're still going to have to prove some sort of knowledge on the promoter's part. But assuming that's true and they can prove that, the promoters will be held responsible according to this court's ruling. But what happens when the lower court does one thing and then the Court of Appeals changes it and kicks it back to the lower court? That does not mean this is done and this is how it's going to be and nobody else is going to fight this, because the defendants can now appeal this again. And we can continue to have this back and forth in this area of the law before we actually find out if these promoters can be held responsible for their tweets and their YouTube videos and things like that. But what I want to know, even though this is kind of an unsettled area of law, what do you think? What does the average person out there think? Should promoters be held liable for what they promote? What is their duty in investigating and finding out how dicey an investment or a product or a restaurant, how good or bad or necessary or whether or not you'll like it? Where is their responsibility? Where is their duty? And then where's the duty of the public? If I'm going to spend my money somewhere, can I just put it all on Jake Paul and say, I'm just doing whatever Jake Paul says? And if I lose, I'll sue him. Or do I have some responsibility where I invest my money? What do you guys think? Let me know in the comments, because this is really important to me and interesting to me. And if you let me know by liking the video that you're interested in this content, I'll continue to follow up on this case, because a lot is going to happen. There will be motions to dismiss filed. All of the celebrities are going to wash their hands of it and say they didn't really know what was happening. They were paid for a specific post. In fact, SafeMoon actually wrote the post for them. They just posted it on their page. They're just like ABC. They're just like a billboard. You can't sue the billboard company. But I'm interested to hear what you guys think. That's just my take on it, on where it's going legally. We've looked at the complaint. We've looked at the case law. We've looked at the causes of action. So you have enough to at least kind of give me your feeling on the case. We don't know everything about it yet, and we're going to learn a lot more through discovery. But from what we know, what do you think? Let me know in the comments. For now, that's all we've got on this case, and we'll catch you next time. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.